the source of income for designer goods is through retail. Now, whether it's through the medium of multi-brand outlets or whether it's through own retail, I believe that social distancing from a perspective of opening of public places will still be enforced for some time, even after the basic curfew is lifted. During that time, it puts us in various forms of conflict with the the lessors. If we have taken up a shop, if we are actually paying high amounts of rent, what is our position as a lessee in terms of can we ask for a waiver of rent?
Yes, so I will answer first the legal position, and then I will answer what is the need of the hour in light of this, unprecedented event. Now, as far as the legal position is concerned, the essential point to see is when you have entered into what you have entered into, whether it is a lease deed to begin with, or whether it is a lease and leave deed. So some people follow a lease deed, and some people follow a lease and leave deed. If it's a lease and leave deed, then it is where, for example, the rights of the entire premise continue to remain with the owner. You are only given a very limited right to use the premise, etc. Then it is covered under what is called as the Easement Act, and because it is covered under the Easement Act, it applies under that act that you are not governed by the provisions of the Contract Act, being which relate to the doctrine of frustration of contracts or the force majeure. You will be governed by exactly the provision that you have provided under the section of the Easement Act, and how a breach will happen. But lease and leave may not apply to you. They may not have been followed in your case, and I'll go to the very basic premise of a lease deed. It could depend upon three scenarios. One scenario is that you've entered into an agreement to lease, correct, which is not a registered document. Now you have entered into an agreement to lease. I have written to, for example, a mall owner and said, I would like to take this place on lease with effect from 1st of May or 1st of April, which condition has not been fulfilled. And therefore, in that case, because that agreement to lease has not been registered, I will immediately invoke the doctrine of frustration under the Contract Act or the force majeure provisions, and I will have zero liability. Right, but those are going to be very limited number of handful of cases where somebody was talking to a mall owner or to a retailer for taking a place which is yet to be taken. Right. The second situation is that they have entered into a lease deed. Right? They're already in some place and they have signed a lease deed. Now the 2 points are critical there. One, whether the lease deed is registered or it is unregistered. If it is a registered deed, only then do you have some scope of rights, because if it is an unregistered deed, the legality of that itself is under doubt. The law basically requires you to register documents in order to acquire certain rights. Now, assuming the fact that you have gone over that requirement and you have a registered lease deed, the lease, so we are dealing with two kinds of contracts. We're dealing with what is called as the Contract Act, and we're dealing with something called as the Transfer of Property Act, right? Now, under the Contract Act, the doctrine of force majeure, which is essentially a French term, was created in order for these with these acts of God and destruction caused by war, etc. And it was encompassed in a section. And the doctrine of frustration came when the ability to execute a contract almost became impossible because of an unforeseen event. Right. So there are two clauses. Now,
so would our current situation definitely classify as frustration?
But that's what I'm coming to. Now, when you have a specific legislation, which in this case is the Transfer of Property Act, a general legislation does not apply. So you will be governed by the Transfer of Property Act to begin with, over and above whatever the Contract Act says. Now, the Transfer of Property Act itself, under Section 108 of the Transfer of Property Act, defines the conditions under which the force majeure clause will apply. So first question to see is that, does your lease deed even have a force majeure clause? If your lease deed does not have a force majeure clause, then you cannot even apply the force majeure provisions.
So that was actually our next question, which is that in case of the absence of a force majeure clause, what happens?
Yeah, so if you do not have a force majeure clause,
and also whether the force majeure clause mentions the word pandemic, epidemic, etc.
Correct.
Okay, so basically what happens is that if you do not have a force majeure clause, then because your lease deed are governed by the Transfer of Property Act, under Section 108 of the Transfer of Property Act, the rights and the liabilities of the lessor and the lessee are both defined. And under the provisions of the definition, it clearly says that if the loss is caused to the premise by fire, by flood, by the violence of an army or a mob or other irresistible force, and any material part of the property is wholly destroyed or rendered substantially and permanently unfit for the purpose for which it was leased, then you may have a recourse. But none of these provisions of
Applies.
fire, flood, applies to this. So
Yes.
if your lease deed does not have a force majeure clause, then you will fall under Section 108 of the Transfer of Property Act, and you will not have a relief under the Transfer of Property Act.
So basically, a poor situation for the lessee at the moment.
If your deed is if your deed is does not have a force majeure clause.
Okay.
Now,
What
if
about
it
the
does have,
leave? Is a leave and license agreement the same as a lease agreement?
no, because that is covered under the Easement Act. See,
And
what happens essentially in a lease is that there is effectively the transfer of the right of the property to you, except not by ownership, but in terms of the actual possession is given to you.
So
So
what
what happens is
in
when
a
a
situation
possession is,
in a situation under the Easement Act, where do we stand?
yeah, so I'll have to in as far as the Easement Act is concerned, again the Easement Act defines your provisions for violation, and those are again much more restricted of the kind. So in Easement Act, again, you do not have the right to enforce force majeure unless it is provided. Yeah, so exactly before, I mean, what I was coming to was that let us first take a situation where you have a lease deed. Let us take a situation where the lease deed is registered. Let us come to a situation where the lease deed has a force majeure clause. Okay, I'm
Right.
looking at scenario one. Now,
Right.
typically what happens is the force majeure clause also has to be defined under the document as what is force majeure according to you.
Okay.
Now, if you have defined force majeure if you have not defined force majeure, then the interpretation of force majeure is going to be taken according to the Transfer of Property Act, and I just read out the provisions under which it will apply, right? Which are not attracted in this situation. But on the other
Right.
hand, if your force majeure clause is drafted well and it says that it will also cover epidemics, government orders, or any other such circumstances that make the conduct of the business impossible, then you would be able to attract them. Now, the second situation is that when you, for example, do not have any provision under force majeure as defined above, can you invoke the doctrine of frustration? Because the
Okay.
doctrine of frustration basically means that the performance of the contract itself becomes impossible. So because of the nature of the activity, which is right now the lockdown, you cannot render the activity for which the place has been taken.
Right.
And here the provisions are basically that the law says that mere economic difficulty or loss may not be sufficient to trigger the doctrine of frustration. Right? So we are not talking about economic difficulties, the ability to pay, and of course the loss is a situation. But there have been court decisions where they say that if the responsibility is not taken, is where they've said that the interpretation may not be taken in such a literal sense of complete closure of business. Because here the thing that is being examined is that the lease is for a defined period, say for example 3 years. Your business may have been rendered ineffective for a term of only 1 month, or maybe 2 months, or maybe 3 months. So, and this activity is not being done by the lessor. When the lessor came and gave you the possession of the entire premise, the premise was fit for being used for the purpose for which the lease was executed. Because you did not define the force majeure, and later you come and say that no, the ability to execute in that premise has become completely unviable. Typically, the law says that you should be giving a notice to the lessor according to the terms of your lease deed to say that I cannot use the premise for which I've taken it, and you have a right to terminate the lease.
Right.
This is a very open-ended situation where even the court does not know whether the lockdown is going to be open on 3rd or 10 days more or less, or whether it will be partly opened, etc. So the difficulty is that when you go to court, you have to prove that my ability to execute the contract has been frustrated for what period, and
Right.
how has it created a economic difficulty on your part. Because the economic difficulty is not a difficulty which is gathered just from the fact that your business is not running. You must also not have the means to pay.
Right.
Otherwise, it is just a business loss. So you
So
had a private
what?
contract between two parties, party A and party B. Now, party A, for example, is the landlord. Party B is a designer who's taken a place. If you are to suffer an economic loss because of an unprecedented event that does not even have a duration, in conceptual sense, the shop could have opened the next day.
Right.
And to open it the next day, the landlord did not have to restore anything. From his side, he didn't have to do anything.
Right.
You didn't see any damage that required him to sort of do anything beyond maybe disinfecting the place, etc. So in all senses, what could happen is that the entire expense that you've been paying can be broken into two parts. One is the cost of maintenance, and one is the rental. If you look at the cost of maintenance, it is easier to argue that the cost of maintenance does not have to be paid,
Right.
right? So the maintenance charges that are charged by landlord, etc., you do not have to pay because it's very obvious that there's no need for maintenance. That's a variable cost based upon an activity to be done.
No,
But
on
because
the
you've
other hand,
contracted,
on the other hand, Safir, both all the landlords that I have reached out to personally have actually said that the maintenance is, of course, definitely payable, because we are still maintaining. We have our guards. We are doing our rounds to make sure that everything is running. We have our people on our payroll who are usually looking after the maintenance. We can't sack them, so it's all payable. It may be reduced slightly, but it's definitely payable. So maintenance, in fact, we are all insisting that has to be.
Absolutely correct, Sapna.
no, so what has happened is that when a place is being shut down, there is effectively, it's like this, that there is no maintenance that is being done except for what is required to be done by the building owner for his own purpose.
The way they are wording it is that this is being done to maintain the property in your best interest, and to keep it up to the mark. And but it's the maintenance is something that possibly will be more difficult because they've got their own payroll bills to pay. Rent is something that still, if they want to continue with you, I guess some of them may come on the negotiation board and try and work out a middle path.
So my point is that in light of the fact that there is a doctrine of frustration that is subject to interpretation, which will look at the feasibility or the lack of feasibility or the practicality or the lack of practicality, which is an issue that the court will decide. You obviously do not want to be in a situation where there is a massive amount of litigation between the landowners or the landlords and the tenants, right?
Right.
They will otherwise, if so, that is one of the reasons why even the Prime Minister of India had earlier made a statement that in circumstances of the kind that we have, which are unprecedented, there should be negotiation between the parties. Now, the negotiation between the parties is subject to the actual nature of the landlord. There may be somebody who will come and say that, your lease period was for 3 years. Effectively, 2 months have been knocked off. I will give you the lease for an extended period of 2 months. So instead of 36 months, it will become 38 months. And the
Right.
entire rent will be payable over 38 months. And to that extent, it will not terminate. For example, if it was to terminate in December 2020, it will terminate in February 2021. And to that extent, you will not have suffered because within the 2 extra months that you got, you would have made utilization of the premise in order to make up for your sales or whatever you had to do.
So what you're
And he
technically
would
saying is
not
that
suffer.
there would be a waiver of rent for this period of time where the shops were closed.
There's a difference between a waiver and what I'm talking. Waiver means
Is
he's
an
just given
extension.
it off.
Right.
Yeah, so your 30 out of his 36 months of earning that he was supposed to get from you, he gets 36 minus the term where he's waived.
Right.
That is a situation where the landlord or tenant can, the mall owner can take a decision. If he decides to waive it, then well and good. See, it's a contract between private parties. One person decides to waive, he decides to partly waive, he decides to defer, is up to him. My
Right.
first situation is that if first solution is that instead of a waiver, which he will turn around and say, why should I lose my money? And you may both be in a battle in court in order to prove whether the money was payable, not payable, whether the impracticality was explained, whether there was economic difficulty, why it did not function on the 20th and opened on 25th, and then, for example, opened in phases. Even that we don't know. So what if they open in phases? They say, okay, you open for alternate days of the week.
Right.
See, so because these things are difficult to prove, the most practical solution is that the tenant says that I will extend the lease by the number of months of this closure so that you
Right.
don't suffer and I also don't suffer.
The other way would be that if you have a very long-term contract and you have 2 months that are gone in this lockdown, you can divide that 2 months of rent over the remaining period of the contract. And in some cases, if it's a 5-year contract, it will be very nominal.
there are also agreements that some designers may have, and I know about some malls that follow the system where the rental is a function of profit sharing. There it's very
Exactly.
easy because there it is zero.
Right.
Yeah, that's the best actually. If one can structure that even going forward, it would be the most preferred alternative. In fact, all business
Yeah.
henceforth should become variable. I mean, seeing this information, what we know now, anybody who's agile and has everything variable is really flexible today. The other thing was that tell me, Safir, have you ever come across cases where industry has taken loss of profit insurance?
Loss of profit insurance.
Is there such a thing? Like, for example, if I have, I'm faced with a fire, so of course I can protect my building, but I can, and my goods and stock, etc. But there is also a concept of loss of profit, right?
Well, there are
In
insurance policies that talk about loss of
Is there
business
such a
as an
thing that you can
insurance.
protect yourself from loss of profit?
question
Yes.
really is that whether such a insurance is possible to be implemented during a time of force majeure or such a case as a pandemic.
No,
If
see,
you had taken it, yeah.
yeah, see, insurances are documents or that are drawn by the insurer based upon his ability to compensate you for certain risks that he evaluates. If you remember this movie Too Big to Fail, and in case you haven't seen it, you can see it. Then at that point of time, the financial community, some people, mavericks, were basically going to the financial community and saying we like to take an insurance in case the US stock market collapses and bonds collapse and banks collapse, and there was no such product, and they created structured products, and they paid a certain premium at that point of time, and these products were created, and those who bet on those products obviously ended up making a lot of money. So this is a true story. There are policies that take into account loss of profit, but the insurance guys are smart enough to word those policies, and sometimes people don't read the nature of the loss. So that loss could be the fact that you don't become insolvent because of certain activities such as which are categorized risks. So you do not, for example, take leverage. You do not do currency doesn't bust. Things. And if you have a letter of credit from a third party or an order from a third party, and that party terminates it at the last minute, then you would have been covered because a contract executed between you and the party had certain provisions of damages. They will look at all those documents and they'll give you an insurance cover. There is nothing as an insurance cover for an uncertainty that is unprecedented and which is not controlled by man.
Right.
Man here in the sense means that this is not a willful act.
Right. So when you mentioned here about contracts with third parties, that brings us to the next one where force majeure, does it apply to contracts, for example, where we have an export order and now it's almost ready to be shipped and the parties turned around and said, don't ship, we are cancelling. Or if we have given an order to someone for fabric and it's already, say, a couple of, like maybe a month into the order, and now we have this situation where our export order is cancelled, so we do have no need of that fabric. How does one deal with all these other contracts that one has?
Yeah, again, the answers are the same as they were in the case of the lease. See, here the only question is that because there is no lease, etc., it's a direct contract, the Contract Act will apply. Now, the Contract Act has got two provisions. One is relating to force majeure, which is covered under Section 32, and one is the doctrine of frustration. I will not confuse you to tell you the differences between the two of them because both of them may come to your purpose. The only point is that it's still a contract can be only enforced for violations of the terms and conditions which are contained in the contract. So when you have entered into a contract for supply of goods to an international party, you have to see two things. First, if your contract does not have a force majeure clause, then you will only go to the doctrine of frustration, right? If you have a force majeure clause, then you will invoke force majeure clause because it is directly provided. And therefore, a take-home point for people entering into contracts in future is to ensure that they have an adequately defined force majeure clause. The second part is that the force majeure clause must define under what circumstance that itself is being invoked. If the agreement says that the force majeure will only apply to earthquakes and some destructions of that nature, which and do not deal with, for example, biological diseases, epidemics, government orders, embargoes, etc., then you could be in a situation or interpretation issue that it is not covered under force majeure, but may still be covered under the doctrine of frustration because it became practically impossible for you to ship or to send the export consignment because of this embargoes imposed. And to that extent, you would be able to invoke the rights against those parties which rights may be in the form of either damages or in form of some remedial steps. But this brings us to the third most important part. When you enter into agreements, particularly with foreign buyers as opposed to India, you may have subject to jurisdictions of countries which are other than India, which is something that only you can examine. If your contract, for example, is with the US party and you say, I subject myself to jurisdiction of US courts, then the contract laws of that country will apply, not India.
I mean, there are people that we know who have an LC backed business and yet it's cancelled and they can do nothing about it other than possibly negotiate with the buyer. Because obviously you're not large enough to start going into their shores and starting to fight a battle with them there.
No, so my first advice, although I'm giving this advice without looking at an agreement, so it's much more generic, but I'm saying my first advice is that the doctrine of in step one, force majeure should apply if your document provides it because it's stronger. If it's not there, and it should cover epidemics or government orders. If it doesn't, then the doctrine of frustration should apply. In the doctrine of frustration, you should be able to prove through evidence that it became impossible, economically impossible to execute the entire contract. But see, what I mean to say is that in proving or the ability to prove that it became impossible, you also have to see the nature of the contract. Let me assume that somebody gave me an order which was to be executed in December, and I was shut down in the month of April, and I had to do my shipment by October. And then on the 3rd of May or 4th of May, the lockdown was lifted. And then I worked overtime and I could have completed the contract. Then the doctrine may not apply. Or I could have done 50% shipment or 40% shipment, then my claim would have been restricted only to what I could not ship. Nobody will give me a sort of a credit to come and say that while you were shut for 1 month and you could have made up in the other period, you did not make an effort and therefore you should get a saving clause.
What about for where we fabric orders, for example, somebody may have already, placed an order for a machinery or items of that nature. Then where do you stand as far as that goes? Similar.
So again, see, when you look at the nature of the order, if I'm buying a machine, in typical circumstances, I would not be buying a machine just for use of 1 month or 1.5 months. And therefore, if a company that is supposed to make the machine, custom make or ship it, or whatever reasons, they say that we are ready to ship it. In most countries around the world, there are still no restrictions in terms of couriers. There's still no restriction in terms of shipping. There are flights that are carrying cargoes all over the world, and it's only a few countries like India that have barred. So they will say that, look, there was nothing from our side. We would have made sure that we put it on a flight and send it, but it got struck at some port other than what port was identified by you.
The drafting of force majeure clauses, because I do have force majeure clauses in many of my agreements, and they do not mention pandemic, they do not mention epidemic, they do mention government causes due to government intervention, but then they go on to define it that if the property is acquired to make a flyover or a bridge, or and then it doesn't say including, it says that is, and that's what the lawyers tell me makes all the difference, because it's not that you've left it open that there are more cases possible, you've closed it. So even wordings, etc., we guys are not careful when we see it from that perspective, but we are paying a price today because of that.
Yeah, while we talk, I just wanted to share two very interesting feedbacks, because like Sapna said, that many people may not be aware of force majeure because they may not have drafted the agreement. I'm talking about people who have signed the agreement, who are, for example, sole proprietors of their business. Their point is that when we see an agreement, we only see the commercial terms. That is all that we are concerned with. This is why I'm saying it's a wake-up call. The commercial terms of what profits you make or what expenditure you make may be one part of the contract, or how long you're getting the shop, but it's not sufficient that you're overlooking other things. And of course, I'm not trying to say that the others should have had the vigilance to look at the definition of force majeure, because this is a very tricky situation, and for all you know, it may also come to you the benefit of the designer. It doesn't have to be. It's just that we're making an interpretation based on law. Now, while I'm talking to you about this, there is actually a decision that has just come out while we are talking today itself. And I will read it out to you. It's just a very short paragraph I will read out, and I will tell you how it could have been to your advantage had we thought better. So there is essentially what has happened is that the Delhi High Court has right now passed an order in a matter which I'll just share details with you, where they say the lockdown prima facie is in the nature of force majeure. Okay. So first of all, the court is saying that the lockdown can be attracted under force majeure. However, this matter involves the invocation of a bank guarantee. And what has happened is that this is a decision that has been passed by Justice C. Hari Shankar right now in a matter which involves an offshore service company, and they have invoked it under the Arbitration and Conciliation Act. So what I'm trying to tell you is that therefore force majeure, that can be a breach, and this kind of breach can be covered under force majeure, would have been your situation, or could have been a situation if you had that force majeure clause in the first place. Now, of course, in some agreements, force majeure may not have been defined only. I'm not even trying to. My first example was that if it is covers epidemic, government orders, it is the best situation. The second is that it excludes them is a terrible situation. Third is that it has not even defined what is force majeure. And then we are only reading under the easement, the Transfer of Property Act, those relevant provisions, where still the doctrine of frustration can somehow be extended. But my main point is that the learning point is that henceforth we should try and invoke these entire provisions, and where the act provides for arbitration and reconciliation, which if, for example, some of your contracts may say that we will not litigate and we will arbitrate, you should invoke that arbitration to look at via media for both the parties.
One there may be a member, a designer member, who actually has a lock-in clause in the agreement. Now, supposing they are in an agreement which still has a 2-year lock-in, I guess in those instances it's even more important, because going forward, if the scenario is such that you'll have 20% footfall, etc., and numbers need to be negotiated, is it they can possibly look for any of these clauses, whether force majeure or the doctrine of frustration, because I presume that if courts have started to look at it more leniently, that in this situation people should be absolved at least from a lock-in clause, if nothing else.
Yes, can be. So again, then the practicality aspect of the contract will have to be brought into limelight. No, that it is no longer practical to be locked in because of some reason. While I'm talking to you, I'm also reading the decision because it just come out. The courts are not sitting and physically entertaining people. The orders are just being passed in emergency matters, and because of lack of printed publication right now, the orders relays are also coming to us electronically. But I'm reading one paragraph which is come out of the judgment, and I'm just quoting the judge, and I think it's a very important paragraph. It says, "We are placed today in uncomfortably peculiar circumstances," which is true about us also in this debate. A pandemic of this nature, which affects the world today, has not visited us during the lifetime of any of us, and hopefully would not visit us hereinafter either. The devastation, human, economic, social, and political, that has resulted as a consequence of this is unprecedented. The measures to which the executive administration has to resort to somehow contain the fury of the pandemic are equally unprecedented. The situation of nationwide lockdown in which we find ourselves today has never earlier been imposed on the country. The imposition of the lockdown was by way of a sudden and emergent measure of which no advance knowledge could be credited to any party. So what I'm trying to say is that these paragraphs are also healthy in a sense. They're supporting you because it is not like in a normal circumstance you could have envisaged doing something which has never happened, of which there could have been no recourse. Even in a situation of fire, sometimes certain things can be salvaged. Here you can't. It's not as if you can even salvage. Not like you can sit in your car and say, "Okay, I'll go to office, and if nothing else, I will work." So these few paragraphs may come to you because the judge is repeatedly saying that these circumstances have not existed in the past and they're unprecedented even for the court, and hopefully they will not be done. It is possible that by some level of mediation that you exercise, either by arbitration or by mediation or by even court, the court also comes and says, why don't you sit and find a solution, which could be one side is 100% rent, one side is zero rent, and one side is, okay, let's find this grace period of extension, let's do 25% rent, you give up something, I'll give up something.
It is up to negotiation and arbitration that can result in some kind of clarity.
Yeah, I'm just saying that at the end of this entire thing, we should also leave some solutions. So I'm saying that one solution is, of course, to become prudent for future, to look at your contracts, to even if the contracts are existing today, to have them redone, so that future contingencies are not done, to take insurances of the kind that Sapna is talking, and to read about insurance policies. But what you're going to do with your, in the case of foreign contracts, to look at where your jurisdiction clauses are. If you are stuck between one end of the contract, then to negotiate and bring it to neutral location so that you're much more comfortable. I mean, if you were in a sense, if you had a jurisdiction like Singapore, perhaps you would have got better relief than, for example, US or somewhere which is much more functional, or some other country which is functional. The third is to find out these is to look at your existing agreement and talk to your landlords and to talk to your laborers, etc., and send a via media. Now labor is much more difficult because of the provisions of the minimum wages, but not the contracts. I mean, take an example that if you were in a mall and all the say 25 tenants of the mall say that we can't pay rent, then you think the landlord will say, okay, all of you give me notice and vacate. That's what I'm trying to say. So he also has to see the practicality.
Exactly. I think today we are the ones who are in malls actually will be protected to some extent, because even going forward, they're saying the kind of practices that malls are going to put in place, they will make sure that it's properly sanitized, the cleanliness, the hygiene, the entire message that goes out is that you're going to be safe inside this place. You know, we are going to take care. Individual shops, on the other hand, I mean, you know, it's difficult because the landlord depends totally on your personal equation with the landlord, you know, and how he's seeing the situation, how he's reading going forward, whether he can easily give that property away to someone else or not, you know.
Absolutely, and also his future credibility. There is something called as the credibility of a guy. It's like this: if the entire world, which according to me it is, if the entire world has gone into a loss of some kind of the other, then to come and say that the entire world should be in a loss but not the landlord also doesn't sound practical. I mean, this is not a personal matter between one tenant and being not paying or being in difficulty and the rest of the mall paying.
Right.
He should also have a cost of subscription to some part of the loss just because of a principle of equity.
Absolutely, yeah.
In fact, his loss is the least because he's not even saving. His business is not destroyed. It's just his money flow is destroyed. In your case, your business is destroyed. It's not your money flow because once an order is gone, it's not about the money flow. The client is gone. The season is gone. The collection is gone.
Right. So on that note, we need to all build up our reserves and hopefully we don't get hit by something like this again.
We had discussed, just as a takeaway from this, what do you think are the most important things? I mean, of course, the need of the hour is negotiations with our respective landlords or the business partners or whoever we're going to be working with, and going further, entering watertight contracts, or really looking at the little things which we miss out a lot of times, which can actually save us or avert such kind of problems in situations such as we are in today. Anything else, Sapna, that you would like to add?
That's it, I guess, and keep look out for the relief package that is definitely coming, and hopefully it should enable us to find some footing. And till that time, keep it flexible. We need to look after our labor, keep giving them advances, and we'll see what needs to be done once we have more clarity on the situation going forward.